this scene for you. A pretty high-stakes legal scene.
Okay.
Imagine the police have a crucial piece of evidence. It's a recording.
Right, like a mobile phone call, maybe about a crime being planned.
Exactly. Think about that job scam case in Saharanpur back in 2009, the one involving Ritesh Sinha. They have the audio.
But having the audio is one thing. You still have to prove who's speaking.
And that's the whole mission. To prove the voice on that recording belongs to the person you've accused.
To do that, investigators need a fresh voice sample from the accused for comparison.
But that immediately runs into a huge constitutional problem. I mean, can the state force you to speak?
Doesn't that just completely go against the right to silence? You know, the fundamental right against self-incrimination we have in Article 23.
And that tension is the core of this deep dive. It's modern forensic needs versus a fundamental right, all playing out in the Supreme Court case of Ritesh Sinha v. State of Uttar Pradesh.
So let's trace how this got to the Supreme Court. The investigating officer, he goes to the Chief Judicial Magistrate, the CJM, and gets an order.
An order compelling Ritesh Sinha to give the voice sample.
Exactly. But Sinha challenged it. He argued it was unconstitutional. And it was such a tricky issue that when it first reached a two-judge bench of the Supreme Court, they split.
Wow, so they couldn't even agree.
They couldn't. That's how deep the conflict was. It had to be sent to a larger three-judge bench.
So what was the central constitutional question they had to answer? Was forcing him to speak the same as forcing him to be a witness against himself?
That was the heart of it. And to find an answer, the court had to dig back into the archives to a really important precedent from 1961.
Kati Kalu Ogad.
That's the one. And that old case provided the key to solving this very modern problem.
So what was the key?
It was this crucial distinction the court drew between being a witness and simply giving material evidence.
Okay, so break that down. What's the difference?
Being a witness is testimonial. It means you're imparting personal knowledge. You know, you're confessing or telling them something from your own mind.
And that is absolutely protected.
Right. But giving material evidence is totally different. That's just about providing a physical characteristic.
Like what? A thumb impression.
A thumb impression, a blood sample, a handwriting specimen. It's purely for comparison.
And the court said a voice sample fits into that second category.
Precisely. Your voice, in this context, is just a physical trait, a biometric marker. They even call it a voice print.
So compelling you to give a sample isn't forcing you to testify. It's just recording a physical characteristic. And therefore, Article 23 isn't violated.
Exactly. That solved the constitutional problem.
But that wasn't the end of it. There was another, almost bigger problem. A statutory one.
A huge one. The court called it a yawning gap in the law.
What does it mean?
It means, okay, so it's constitutional to take a sample, but did the magistrate, the CJM, actually have the legal authority under the law to order it?
And the Criminal Procedure Code, the CrPC, it had sections for ordering medical exams or handwriting samples.
But on voice samples, it was completely silent. Nothing.
So criminals could potentially get away with things simply because the law hadn't caught up with smartphones.
That was the risk. A huge procedural loophole.
So how did the Supreme Court close that gap? They can't just write a new law, can they?
Well, in a way they did. They invoked their most extraordinary power, something under Article 142 of the Constitution.
The power to do complete justice.
It's their ultimate trump card. They said procedure should be the handmaid of justice, not the mistress. So, to prevent a failure of justice, they stepped in.
And what did they do?
They passed an order that, until Parliament gets around to amending the CrPC, every judicial magistrate in India is empowered to compel an accused to provide a voice sample.
That's a massive act of, judicial activism, isn't it? Stepping into the legislature's role.
You could call it that, but you could also call it a necessary update for the digital age. Without it, investigations could just stall on a technicality.
So let's wrap this up. What's the practical takeaway for you, our listener?
It's very clear. Under Indian law right now, your voice is treated like your fingerprint. It's physical identity, not testimony.
And if a court orders you to provide a voice sample, the right to silence won't protect you from refusing.
Exactly. And refusing can lead to an adverse inference being drawn against you in court.
I think the final thought here is just how this whole case proves that the law isn't some static thing.
Not at all. It's a living entity. It has to evolve. It has to adapt as technology changes the very nature of what we consider evidence in the modern world.